Good morning, everyone. Bonjour à tous. Thank you for being here. Tandis que les codes provinciaux des droits de la personne dans Québec et dans la plupart des provinces et territoires interdisent la discrimination fondée sur les convictions politiques. Ces interdictions ne sont pas universelles et il n'existe aucune protection de ce type au niveau fédéral. Cela signifie que, pour le moment, les Canadiens peuvent être victimes de discrimination de la part du gouvernement fédéral et d'acteurs privés en raison de leurs convictions ou activités politiques. Le projet de loi 257 changerait cela. Le projet de loi 257 que j'ai déposé à la Chambre des communes hier ajouterait la conviction et l'activité politique au Code fédéral des droits de la personne en tant que motif de discrimination interdit. Canadian law has a problem with allowing political discrimination. While provincial human rights codes in most provinces and territories prohibit discrimination on the basis of political belief, those prohibitions are not universal, and there are no such protections at the federal level. This means that, for the time being, Canadians can face discrimination from the federal government and from private actors on the basis of their political beliefs or activity. Bill 257 would decisively change that. Bill 257, which I tabled in the House of Commons yesterday, would add political belief and activity to the Federal Human Rights Code as prohibited grounds of discrimination. This bill is about protecting the rights of individuals, their freedom of speech, and their freedom to be involved in the democratic process without facing reprisals. But it is also about realizing the benefits that come from a free society and a robust civil democracy. If individuals are constrained in their ability to present unpopular ideas by the risk of employment-based or other forms of political discrimination, then our democratic discourse will lose the opportunity to be pollinated by new ideas. A democracy in which people can face discrimination and reprisals for presenting political ideas is less competitive and more constrained. Political discrimination also risks giving private corporations a dangerously outsized role in our democracy. If a private company can require their workers to involve themselves in activities of a political nature, or discipline employees who participate in political activities which contradict the political values of the company leadership, then they are using their corporate power to shape democratic decision-making. It would be sad and inconsistent if, after banning corporate and union donations to political parties, we allowed these same entities to control politics through the coercion of their employees. Private corporate actors could seek to influence politics in other discriminatory ways, such as through discriminatory advertising or content policies. And these too are areas where corporate power should not be allowed to tip the political conversation to their advantage. There is also the risk that governments or public entities use their leverage to induce private corporations to use political discrimination to shape the political conversation, without the kind of transparency that direct government action requires. Private companies are not allowed to donate to political parties, but they can use political discrimination which supports the government positions to curry favor with a party in power, and this should not be allowed to occur. This is a long-standing issue and risk, but the government's recent use of the Emergencies Act really brings this risk into sharper focus. The Justice Minister explicitly demonstrated that political views were a factor in considering whose bank accounts should be frozen. As Conservatives said at the time, we oppose the breaking of laws. But the inconsistent application of those laws to different kinds of protests and the risk of application of sanctions by private banks acting at the behest of government to individuals who had actually not been involved in lawbreaking, this raises serious concerns about the kind of political discrimination that we are allowing to take place. Other policies of the federal government, such as the summer jobs values test and the government's stated intention to politicize charitable status determinations, raise the same issues and concerns around political discrimination. But rather than just playing whack-a-mole and confronting these specific situations as they emerge, we should have a law of general application, which protects all Canadians from discrimination on the basis of their political views. Because one day it could be the other way around. Maybe one day a conservative government will face similar criticism. Either way, workers and all Canadians should have their rights protected and should be able to express themselves and involve themselves in the democratic process without fear of political discrimination. Now, in closing, I want to emphasize 3 important points about how the Human Rights Code is applied. First, human rights codes in Canada do not just apply to immutable characteristics. As mentioned, prohibitions against political discrimination exist in most provinces. The Federal Human Rights Code prohibits discrimination on the basis of religion and marital status. Religion and marital status reflect deeply personal and important decisions and realities, but they are not immutable characteristics. I think a strong argument can be made that political beliefs are held and felt with a comparable level of personal attachment and intensity for at least some individuals. Now, secondly, a right to be free from discrimination on the basis of political belief or activity exists in the context of other rights and also other law. My bill does not touch existing laws on criminal activity, which may be politically or ideologically motivated, including hate speech laws, and it does not prevent an employer from imposing employment-related consequences or other consequences which are necessary for the protection of other rights. And thirdly, Section 15 of the Canadian Human Rights Code explicitly allows employment-related rules that might otherwise be considered to discriminate, but which are based on a bona fide occupational qualification. There are many jobs where political alignment or political neutrality are legitimately relevant to the job in question. It is reasonable, for instance, for members of Parliament or not-for-profit advocacy organizations to want to take into consideration whether the political views of the staff they hire align with their own general worldview and mission. Certain positions, such as judges or election workers, also require political neutrality. Employers will want to continue to set these requirements in these cases and will be able to do so in accordance with the exception in Section 15 of the Human Rights Act. Exceptions for bona fide occupational qualifications are legitimate and important, but an employer should not be able to influence the political activity of an employee outside of an area where there is a bona fide occupational qualification. The precise determinations around what constitutes such a qualification can build on a long-established body of law applying the federal human rights codes and can draw from the experience of existing rules against political discrimination that exist at the provincial level. Now, some might argue that political neutrality should be a bona fide occupational qualification for our friends in the press, but I'll happily affirm that the law should leave those determinations up to private companies. And with that, I will take your questions.
And we'll now take questions. Since we don't have anybody in the room, we'll take questions online. Nous allons maintenant passer aux questions. Comme nous n'avons personne dans la salle, nous prendrons les questions en ligne. La première question est pour Hélène Buzetti. Hélène, la parole est à toi.
Oui, mon micro ne s'ouvrait pas. Hi, Mr. Genuis. I'm just curious, you gave 2 examples, the Emergencies Act use and also the statement that was required by the Liberal government. But do you have examples of private employers who did such kind of discrimination, which would have triggered your bill?
Well, I think we have seen cases related to this that have been brought forward in jurisdictions at the provincial level, which already do look at cases like that. I don't have any specific cases that have been brought forward in federal jurisdiction, but of course, it's not currently prohibited in the code in federal jurisdiction, which is why we're bringing these forward. But there's a body of case law, for instance, from British Columbia. I know that deals specifically with a number of different kinds of cases, looking at different applications of it. So we do have instances where, in cases where these provisions exist at the provincial level, they have been used by employees with concerns about discrimination.
Yeah, I understand, but I was wondering if you had in mind a case of a private employer that would have discriminated against an employee based on his or her political ideology, and which were not reprimanded because it's allowed at the federal level.
Well, again, we've seen at the provincial level how these cases have come forward. These cases haven't come forward at the federal level, and I don't have any to specifically reference because it's not currently a prohibited grounds of discrimination. there will, I'm sure, be instances where these cases will come forward. There have, since they've happened at other levels, it would be reasonable to assume that if it's been a problem in provinces where people have been able to raise these concerns, that it also exists within federal jurisdiction, even though people have not actually been able to come forward right now and raise those concerns.
Thank you.
The next question will be Stephanie Lewitz. Go ahead, la parole est à vous.
Hi, good morning. Thanks for taking our part.
Sorry, Stephanie. Go
That's
ahead.
okay. Am I unmuted now?
Yes.
It wasn't me.
Yes, perfect. Okay, it was me.
Yeah.
You'd think, 2 years in, we'd know how to unmute, but no. Thank you for taking our questions. I wonder, Garnett, if you could just reflect a minute on the need for this bill, in your view. Like, I'm thinking of it in the context of yours is the latest bill to come before Parliament that touches on some of the realities of modern day political discourse in our country. So, for example, your colleague Kevin Waugh has a bill about banning Holocaust denial. There's bills about banning hate symbols. There's now this bill that sort of addresses discrimination based on political ideology. I realize your bill doesn't, reverse their bills, but that you feel that we're at a place where legislation is required for this. And I wonder if you could just reflect on that.
Sure. Well, I think many Canadians would be surprised to find that there aren't already protections against, for instance, an employer saying, I don't like the fact that you volunteered for this political party, and therefore I'm going to impose some consequence on you for that, or saying that housing or that some of those things could be constrained on the basis of political views. I think Canadians would be surprised that it's not already in the law, or it's not already a given, and part of what we need to do is fill in those gaps. But Stephanie, I think also in terms of why a bill like this is important right now, we are seeing this trend in society where there's a greater intensity of political feeling and action, where for some people, political beliefs take on the same kind of intensity of significance for them that maybe religious belief was more likely to take on in the past. And so given how much political beliefs can come to be core to a person's identity, it makes sense to see that as a potential grounds of discrimination. And I would also say that I think we have seen some cases in terms of actions by the federal government that point to the need for having these kinds of protections in place.
Thank you. Just as my follow-up to pivot entirely to the Conservative leadership race, and I'd like to hear from you, in your view, what you think this race ought to be about. What is the ballot box question, do you think, for grassroots party members?
I think the ballot box question will be whether the leadership candidate in question is enthusiastically in support of Bill C-257.
Thank you. This concludes the press conference. Ceci met fin à la conférence de presse.
Thank you very much.